Hello, welcome back to my YouTube channel. If you are new here, I want you to consider subscribing because I will be sharing my insights on legal and political issues within and outside Nigeria. And if you are subscribed, welcome back. It will be recalled that former Vice President Atiku Abubakar has sought the help of United States Court to compel Chicago State University to verify the fact that the incumbent president of Nigeria, Bola Ahmed Tinubu, has attended and graduated from the university and that it should produce the academic records of the president. The court has since granted his plea and the university has already furnished him with all the documents he required. But then, the election petition instituted by the candidate of PDP, Atiku Abubakar, has already been decided by the Court of Appeal, sitting as the Presidential Electoral Tribunal in favor of President Bola Ahmed Tinubu. Though this recently gotten evidence from Chicago State University was not pleaded in the tribunal, Atiku wants his lawyers to seek the permission of the Supreme Court, which will be the last appellate court on this matter, to allow him include this novel evidence showcasing the seeming discrepancy between the certificate fielded by President Tinubu to the INEC and the one shown to the Atiku by Chicago State University. The question now is that, will the Supreme Court listen to this request? Will it consider this new evidence that wants to be used in nailing Mr. President? Well, when we look at Order 2, Rule 12 of the Supreme Court rules, it says that a party who wishes the court to receive the evidence of witnesses, whether they were or were not called at the trial, or to order the production of any document, exhibit, or other things connected to the proceedings in accordance with the provisions of Section 33 of the Act, shall apply for leave on notice prior to the date set down for the hearing of the appeal. The application shall be supported by affidavit of the facts on which the party relies for making it. This provision clearly shows that Supreme Court has power to receive new evidence on appeal. The issue of forgery is a very serious crime in Nigeria, and according to Section 137 of the Constitution of the Federal Republic of Nigeria, it says that whoever forges his certificate should be disqualified from the exalted office of the President of the Federal Republic of Nigeria. So the question on whether Supreme Court can accept new piece of evidence sitting as an appellate court can be said to be answered in the affirmative. Court of Appeal has since designed grounds upon which new evidence can be admitted in an appellate court. In the case of Amechi vs. INEC, it lists the grounds as follows. Number 1, the evidence must have occurred after the trial court gave its judgment. 2, the evidence must be such that it could not have been obtained even with reasonable diligence at the trial. And 3, the evidence must be relevant to the case at hand if admitted. So though this video is not about predicting the outcome of the appeal suit before the Supreme Court, but it is a light to show that the Supreme Court has indeed power to accept new evidence on appeal if it meets the requirement the court wants. With this, we have come to the end of today's video. If you have different perspectives or questions, you can share them in the comment section below, and I'll make sure that I respond all of your questions. And please, if you are yet to subscribe, do well to subscribe for me so that you support me and encourage me to make videos like this. We meet again. Bye bye.